So the progressive era is going to start to lead to some changes. It's an era between 1890 and 1920 that we're going to see America changing. Technology is going to start to change America. Um, the advent of people moving into larger cities and interacting more with different people from differing backgrounds is going to start changing America. We're going to see some changes in child labor. Monopolies are going to start being broken down, and there's going to be some more competition among business. We're going to see in certain parts of the United States, we're going to see suffrage for women, which is going to be a huge change because now we have, depending on where you live, some women can vote and some women can't. Political corruption is going to be start to be put into check, and there's going to be some addressing of prejudice in the United States as well. So one of the cases that you're going to have to remember, again, I told you I would let you know what they are. Plessy versus Ferguson is an 1896 case. Supreme Court case that challenged the Louisiana statute requiring that railroads provide separate accommodations for blacks and whites. So Plessy is an individual of interracial background. He is, when I was growing up, there was a terminology that was used. I don't know if it's overly politically correct now, but it's called passing. It would be African Americans who had enough interracial blood in them, with more than likely Caucasian individuals, that they had characteristics that would resemble more of a Caucasian white individual than a black person. But under the rules of the day, that one drop of black blood or minority blood in under the law made you that minority. So Plessy, if you looked at him, you would think he was actually a white American. And so Plessy had probably done this before, but Plessy would travel on a train, and he would buy a ticket to the all-white car, and the person selling him the ticket, looking at Plessy, thinks he's white, and so he sells him a ticket to the all-white sleeper car. And he gets on the train, and as they're traveling on the train, the engineer goes through the train checking people's tickets. It's important that you have your ID and your ticket, and you're in the space on the train where you paid for and you're supposed to be. And an engineer would usually rectify, where you're supposed to be. And so, if you didn't have a ticket, you need to buy a ticket, or they're gonna, put you off the train. And they usually didn't stop the train when they put you off the train. Or if you're in the wrong section, they would make sure you were in the correct section. So the engineer gets to Plessy, and they check his ticket, and then they ask for his ID. But on his ID, it's going to say that he's mulatto, which means he was of an interracial background mixed with white and black. Because, again, he's from a Creole background in Louisiana, a French and African background. And the engineer says, you're in the wrong section. And Plessy's like, well, I paid for the sleeper car. And he says, well, but you can't be here because you're not white, and these are white only. And so you can go to the quiet car for African Americans. And so that's a car where you have to be quiet, but it's not a sleeper car. Sleeper cars are like your own little rooms that you get on the train where you can lay down or use as you see fit. Quiet cars are still it's a shared entire car of a train for multiple people. You just have to be quiet. And so he argues that, he paid for the ticket and is right. But an argument over this ensues, and he sues, and it goes all the way up to the Supreme Court. And at this time, the Supreme Court rules that separate but equal accommodations do not violate the Equal Protection Clause of the 14th Amendment. So the Equal Protection Clause exists, but the Supreme Court says as long as there's a separate but equal, two separate but equal standings for whites and minorities, this can be allowed. And Plessy versus Ferguson is going to sanction a segregation in all accommodations from this point until the next, and really for the next 70 years. And this is going to become society. So again, Plessy is going to nullify a lot of the provisions that we saw in the Civil War amendments, a lot of the parts of 14th Amendment, and create a standard of separate but equal and really all accommodations, because the Supreme Court says as long as it's separate but equal, it's allowable. And society is going to grow out of this. And there are many groups that come into existence to fight this discrimination that now is sanctioned and put in place by government. The National Association for the Advancement of Colored People, or the NAACP, which is devoted to the problem of the Negro, mainly designed to address the issues of minorities, but also address issues of women and children as well. The National Association for American Women's Suffrage Associates, which would later become the National American Women's Suffrage Association, or NASA, devoted to women's suffrage movement and the drive for getting women the right to vote all the way up to 1920. And their actions do work, because in 1920 the 19th Amendment is passed, and which guarantees women, and this is all women, no matter what their race or their background is, the right to vote. The right was given to 50 years after African American men were allowed to vote. So again, we've seen 3 amendments in this chapter so far: the 13th, 14th, and 15th, and the 19th. And so we have some ways of addressing this segregation. So I'm going to use this in the context of a family member. I'm going to use this in the context of my mother-in-law. She's a great example of this. Society has adjusted for how law was made. Plessy versus Ferguson is the 1896 law. And so from 1896 to, at the minimum 1954, which is where Brown versus Board of Education happens, and really into 1960s, early 1970s, we have discriminatory segregation. And the segregation is legal under the Constitution because of Plessy versus Ferguson. And so society is going to create paralleling existences for whites and minorities. Or let's just take African Americans, for example. So you have white elementary schools and you have black elementary schools. You have white middle schools, you have black middle schools. You have white high schools and you have black high schools. You had white colleges, and then many of you who live in the South might have heard of a historically black college and universities that used to mainly only educate African Americans, but now have multitude of races that go to them today. But they used to, because African Americans couldn't go to the white colleges here in Georgia. They couldn't go to Georgia State or UGA or Georgia Southern or any of those other schools. You had to go to a Fort Valley State or an Albany State or a Savannah State or a Morehouse or Spelman or Clark Atlanta. There's a plethora of them in Georgia. But those are historically black colleges and universities. So what happens is, when the challenge to separate but equal comes into play and is promoted, we have to find a area that's not separate but equal. And so let's take my mother-in-law. She went to an elementary school. She went to a white-only elementary school, white-only middle school, white-only high school. When she went to college, she went to Tennessee to Fisk University. It's a excuse me. My mother-in-law went to black-only elementary school, black-only middle school, black-only high school. And when she went to Fisk University, she went to, it was a historically black college and university. And my mother-in-law is a dentist, and so she went to Howard University, which was also a medical school for African Americans. There was only 2, Meharry in Tennessee and Howard University. And so she has a whole education all the way up to being a doctor of dentistry that was in classrooms that were only in African Americans, because those are the classrooms that she had to interact in because of segregation. And so the only place, because even middle schools are segregated, the only place where there wasn't a separate but equal school were law schools. There weren't a lot of African Americans going into law. Many of them had to go really up to northern states where schools were already integrated in order to get legal education. But there's the challenge for the NAACP began in law schools, which is very important. That's the place it began, law schools. So it began by challenging separate but equal in law schools. Most states did not provide post-secondary graduation education for African Americans. Grimes applies to the University of Missouri Law School, was rejected, not because he didn't have the scores or the grades, but sheerly on the fact that he was African American and the school was not integrated. And so he sues. And the case goes all the way up to the Supreme Court. And the Supreme Court says, Mr. Grimes, you are not, you have the criteria to get into school. In Missouri, you have a choice to make. You can either, since there is no separate but equal school, you can either build a school for Mr. Grimes and the subsequent African Americans who will go to law school, or you can admit him into the University of Missouri Law School. And Missouri looks, and they're trying to gauge how many minorities will be going into law school. There's not many, so they're looking at the cost of building a school for minorities, and it's not really cost effective, and so they admit Mr. Grimes into University of Missouri's law school. Now, Supreme Court cases are very interesting. When Supreme Court rules on an issue, they can rule it narrowly or broadly, meaning they can rule it narrowly, meaning it only affects those who are parties to the case. So in this instance, this ruling only affects Grimes. It affects no one else. Or they affect it broadly, where it means that we're changing how we understand the Constitution, or we're clarifying how we understand the Constitution, and the ruling that we make is going to affect everyone. Now, in this case, the Supreme Court rules narrowly, and it only affects Grimes. And it's very interesting because if you ever see pictures of Grimes sitting in his classroom, there's actually a partition in his classroom where the rest of his classmates are sitting in one area of the class, and he's partitioned away where they can't see him, and he's sitting in another area of the class. But this is going to create what is called precedent, a standard that we can go by to make future law. And so another case comes about, Sweat versus Painter. Sweat applies to the University of Texas Law School, all-white University of Texas Law School by law. Was denied. Again, he has the scores, he has the grades, but denied sheerly on the fact that he's African American. The judge rules the same as they do in Grimes and say, Texas, you either have to build a separate but equal school or admit Grimes into the University of Texas Law School. And because it's Texas, they built a school. Now, they didn't really build a school. They took an old middle school and they converted it and made it a law school. Now, the building itself is really not the issue. But the University of Texas, even today, if you look it up, is usually for public schools, especially, is usually in the top 10 of public law schools in the nation. And overall, a couple years ago, I know it was in the top 5, period, for law schools. It's one of the great law school to get into. And even at this time, the University of Texas was a good law school. And so the school that they built was not the same as the school that what the University of Texas was. University of Texas, you had the most modern books, you had seasoned professors, you had a pedigree of the school. The new school they built had a different name, had brand new professors, had hand-me-down books. And the court looks back at the schools that they create and say, hey, this is not an equal school. And they integrate the University of Texas for Sweat. Again, narrowly ruled upon case where Sweat is allowed to be admitted into the school, even though he is, he's a minority. But it only affects Sweat. And so the NAACP uses these two cases, Grimes and Sweat, to lay out their argument for Brown versus Board of Education. A case you're going to have to remember. Brown is actually 4 cases, Brown 1 through Brown 4. And they argued that separate but equal was not constitutional under the Equal Protection Clause of the 14th Amendment. Separate but equal hampers and harms the intellectual, psychological, and creates financial damage upon African Americans. Again, intellectual, you're not getting the same education. The same resources are not being sent to the minority schools, and so they're not really getting the same education. Psychologically, you know that you're second-class citizens and you're being treated in a second-class way, and so it creates a financial harm. Harm psychologically and financially. The people who hire you know that you have a background that is not equal to the individuals that you're graduating with, during that same year from a different school, and you're not as marketable because they're not going to hire you when they can hire somebody else from a high school that had the education that they deem to be appropriate. And so the Supreme Court concludes that in the field of public education, the doctrine of separate but equal does not have a place. So we had Plessy versus Ferguson, which creates a universal doctrine of segregation. And then we have Brown versus Board of Education, which is the first major case that is going to start dismantling that segregation. And it starts in public schools. The thing about Brown versus Board of Education is that because they ruled that there's schools should be integrated in 1954, it doesn't mean that immediately schools started integrating. Some of them did, but we have Brown 2, 3, and 4 because there are certain things that are going on that are creating problems. In Brown 2, the Supreme Court ordered that integration should happen with all deliberate speed, because in Brown versus Board of Education 1, they didn't say when integration should happen. And many schools just say, well, we'll integrate when we integrate. And many schools purposely try to slow or prevent integration as much as they could. In Arkansas, Governor Faubus used the state's National Guard to prevent integration. In response, President Eisenhower sent the Federal Army troops to Arkansas to ensure integration. The Army absorbed the National Guard, and many of the same troops that were preventing integration were now, helping in walking students into the school and protecting them from the crowds. I guess probably one of the more interesting uses of this same instance, where you see in the movie Forrest Gump, where the soldiers are holding back the students when they were integrating the University of Alabama under that movie. And the young lady drops her composition notebook, and Forrest picks it up and hands it to her. Those are some of the things that are going on. Cooper versus Aaron, a Little Rock School Board asked the state and the federal government for 2.5 years of delay. And their 2.5 years of delay was actually so they could dismantle their public school system and create a fully private school system. The Supreme Court realized what the Little Rock, Arkansas School District was trying to do, and said, you know what? For you trying to be purposely evasive, you are integrated now, and forced the integration of that school. So you see in these instances where people did not want to integrate, but the Supreme Court and the federal government then started weighing in to create integration. Integration in public accommodations, though, happens at a slower pace. We have integration in schools, well, at least the Supreme Court decision that says schools should be integrated, but that does not affect the everyday business. So like restaurants and theaters and buses are not affected by Brown versus Board of Education. And so in 1955, Rosa Parks gets on a bus and sits down. And then as the bus starts to fill up with white patrons in Alabama, she's asked to move and give her a seat. And she refuses not to do so, and she's arrested. After she's released from jail, the NAACP and the Southern Christian Leadership Conference, which was headed up by Dr. Martin Luther King, joined her, and they created the Montgomery bus boycott. They walked, carpooled, and used black-owned taxi companies in order to boycott the bus system of Montgomery, and which eventually would lead to the integration of buses in Montgomery and the integration of other systems. Why was this bus so important? Why was the bus issue so important? Well, many people in the African American community couldn't afford cars, and the bus was the main means of transportation. Their main means of transportation from one place to another, and so they needed the buses. And the buses, if you ever look at a transit bus, it's not like a school bus. School buses, you have that one door in the front right that you get on and get off of. Everybody gets on that door. Everybody gets off on the door unless an emergency, where they have that back door where you can jump out the back. Or, in modern buses now, they have that little escape hatch that you can, if the bus gets tilted over, you can get out there. But on a transit bus, you actually have two doors. You have a door up by the driver and then a door about halfway through. And the way those buses are supposed to work is you're supposed to, when the bus stops, you get on, you pay the driver, then you go take your seat. When you're ready to get off at your area, you get off on the middle door, and you get off on the middle door, you get on the front door, you get off on the middle door. So the traffic is light, so you don't have to fight against anybody who's trying to get on in the on door or off at there's no traffic at the on and off doors. But for African Americans under this time, it was a little bit different, because what you did was, on those buses, the first couple sections of the bus were white only. And so you would, as an African American, you would pay. You actually had to get back off the bus and then wait at the second door for the bus driver to open the second door for you to get on the bus, so you couldn't walk through the whites only section. And so there would be many times where, because you had that white only you had to wait for the bus driver. Bus drivers didn't care. They got their money. They would drive off, and you'd be standing at that same spot that you were standing, had paid your money, but not getting a ride. The other dynamic that existed, and this affected Rosa Parks, was the bus sections were variable. As the bus filled up with white patrons, the white section would get larger and the black section would get smaller. Actually, in some of the buses, they had a little kind of conveyor piece that slid back, and as the bus filled up with white patrons, the white section would grow and the black section would get smaller. And then usually in some instances, there would just be the back wooden bench where it was black only all the time. But you might be on the bus, paid your money, and the bus started to fill up with patrons, and you had to get off the bus before you reached your destination because a white patron could take your seat. And so those are the two major things that are going on. And so through the NAACP and the Southern Christian Leadership Conference, the Southern Christian Leadership Conference, the SCLC, we start seeing that, the African Americans are going to start walking and carpooling and using black-owned taxi companies. There were, white-owned taxi companies, and there are black-owned taxi companies to get to work. And in 1956, the federal court ruled that segregation of buses by race violated the Equal Protection Clause of the 14th Amendment, and this public accommodation was desegregated. There are many organizations that fought segregation. We talked about the NAACP. We also talked about the Southern Leadership Conference, which was headed by Dr. Martin Luther King. Was rooted in black religious culture and stressed nonviolent protest and civil disobedience. It actually, churches were probably one of the main sources of political involvement from minorities, even today. The church is a huge part of where me being an African-American male, conversation about government and what's going on in society still exists for today. It was a huge foundation during this time. Birmingham was the next target for the SCLC. Thousands of black Americans and white Americans marched in Birmingham as a show of solidarity. However, the police commissioner in Birmingham was not happy about this integrated march and ordered the use of dogs, clubs, and fire hoses on the marchers, and that was caught on tape. A lot of what happens and a lot of what gets addressed from this point on is because Americans, through the invention of television, are going to be enlightened by what's going on in the world. A lot of people really are kind of ignorant to what was happening during this time, and television is going to change it. People might read it in the newspapers and people might read that information, but being able to see that violence and what's going on their TVs is going to bring it into their homes, and people are going to be affected by it and want to change it. And so this is kind of the step of where we start seeing some of that change about where segregation is going to end, because it's coming into the homes of people who aren't really affected by it, but they're going to start weighing in. We even see the Student Nonviolent Coordinating Committee. I put this in because you guys are students, but these are students making a difference through sit-ins and freedom rides and peace marches. This is very dangerous. If you ever see a picture of somebody doing a sit-in in a cafeteria, they're usually covered with food. And sit-ins at diners are not the easiest thing to do, because people are pouring their hot food on you, especially if it's a breakfast. And you have to sit there and take it, because if you jump up and show any sign of what would be considered as aggression, you're going to go to jail. Not them who assaulted you by pouring stuff on you, but you who was just responding to the hot coffee that just got poured on your head or in your lap. So those are some of the things that you have to take into consideration. This was very dangerous. People died, but they were fighting for what they believed in. What's going to change America, again, is Americans seeing this, the strife and the pain of what's going on, and seeing the churches being bombed and set ablaze, and people coming in to address the issues of the day. And the Civil Rights Act of 1964 is going to make a large step into rectifying a lot of this segregation that is existing. That along with the Civil Rights Act, the Voting Rights Act of 1965. So our Civil Rights Act of 1964 is going to state it outlawed arbitrary discrimination in voter registration and expedited voting rights lawsuits. So people who are trying to vote and then are being denied, those cases are being rushed up to the courts so they can be addressed. So People could have the right to vote. Because again, elections aren't a long period of time. And if you're denied the right to vote, you don't really have a lot of time to wait for the courts to make that decision over months. The courts need to get to the case needs to get to the courts. The courts need to make the decision so the rights can be honored. Ban discrimination in public accommodations engaged in public in interstate commerce. So if you have a business that operates in interstate commerce, meaning that your business or your good of your business or the operations of your business across the state lines, the federal government has the ability to weigh in, and the 14th Amendment Equal Protection Clause applies. So if you have a business that operates in interstate commerce, the 14th Amendment Equal Protection Clause applies, which means you can't discriminate against somebody. And almost every business today operates this way because we are a society of finding the best good at the cheapest price, which means for the most part, that's not going to be from your state. So say if I want to open a barbecue joint and I say, yeah, you know what, I am a Black American and I only want to serve Black Americans at my barbecue shop, and so I'm going to discriminate against all white individuals, I would have to show that none of my business operates out of the state of Georgia, which is where I live and which my business resides. But if my wood that built my building came from a state outside of Georgia, it wouldn't apply. If my tables were built with wood that came out from the state of Georgia, if my napkins were made from paper, from wood, from trees that didn't exist in the state of Georgia, if my spices weren't grown and processed and bottled, and the bottles didn't come from somewhere in the state of Georgia, if any part of my business existed outside of the state of Georgia, in the operation of my business, the federal government had the right to regulate, which means the 14th Amendment Equal Protection Clause applies, which means you can't discriminate on the basis of race. If you have today, even if you have a small business today, if you took cash and it didn't have, and no part of your business operated outside the 14th Amendment, outside of the state of Georgia, you probably could still discriminate if you wanted to and be protected. But the vast majority of businesses operate across state lines, especially since the vast majority of us have a little piece of plastic in our wallets and purses that every time you swipe it, the vast majority of banks don't reside, their headquarters don't reside in your state. They usually reside in Ohio or Delaware or Texas, which have very lenient banking laws. And so that information is going to their servers in those states, and then it gives you back the information, and then it prints out your receipt. So those are still operating in interstate commerce because that electronic signal crosses state lines. Authorizes the Department of Justice to initiate lawsuits to desegregate public schools and facilities. Any school in schools for public schools usually get some sort of federal money through the state, and almost every college uses federal loans and other federal programs to help educate students. If you take federal monies, you can't discriminate against a person on the basis of their race. Prohibited discrimination in employment on the grounds of race, creed, color, national origin, and sex, and created the Equal Employment Opportunity Commission to monitor and enforce the bans on employment discrimination. We talked about equality a lot over the last couple minutes, but we don't talk about anything that has to do with gender. And so we're talking about all of this equality, but still women are left out. Many women are going to leave a lot of the groups designed to create equality because they're just addressing racial equality. And you're going to see over time that women are going to leave to join groups that are going to address the issues of women. And so we saw in the 1970s a push for the Equal Rights Amendment, which would have placed all women on the same equality scale as men. Now, again, that exists in how we believe, but that doesn't mean it exists in the actual essence of how people act in the world. Women still make 80 cents on the dollar that men make. So a woman with the same education, doing the same job in our society today, still makes 80 cents on the dollar that a man makes, just because the mindset that some individuals have out there in the world. So in 1972, Congress voted in favor of the Equal Rights Amendment, proposed the amendment to the Constitution. Equality of rights under the law shall not be denied or abridged by the United States on any state on the account of sex. again, would have placed gender on the kind of in the same category as we placed race. However, it was not ratified by the states, and so it did not become an amendment to the Constitution. We do have gender is accounted for when it comes to the Equal Protection Clause, but our Equal Protection Clause has levels in which it labels your freedoms. The most protection is actually given to our fundamental freedoms and our suspect classifications under strict scrutiny. So when we're looking at this, I haven't actually minimum to most strict, but let's talk about it from strict down. It's actually easier to understand if we start at the top, which is actually at the bottom on the slide, and work our way to the bottom. On the next slide, I re-give it to you in a chart, and it puts strict scrutiny at the top. So for our understanding, let's work from top to bottom. So the most regulation and the most protection is given to things that fall under strict scrutiny, which are our fundamental freedoms, our speech, press, assembly, and religion, and our suspect classifications, our race, color, alienage, national origin. Yeah, let's make sure I didn't miss anything. Class or category class such as race that triggers the highest level of our Equal Protection Clause. There's no real reason why we should be discriminating on the basis of race or color or national origin or creed. And so that is the highest level. On the intermediate level, we have gender, and we may have sexual orientation falling under this. We're still trying to figure out how Obergefell applies when it comes to sexual orientation. But gender is under immediate scrutiny, and it's pretty much the only thing that exists. There's a case called Reed versus Reed, which establishes that there's no difference between men and women, and so we should be looking at the characteristics of the individual rather than what they're born with, or what their gender is. And so at the top, there's strict scrutiny. Then we get to intermediate, which only covers gender. There might be in intermediate, there's an argument that there may be some reason that we might discriminate on the basis of gender. A lot of those principles that we think about that made gender fall into intermediate are kind of going away. Men and women, for the most part, for all things, are equal. So in our society today, and I'm just talking about societal understanding. So a lot of the things that used to segregate us and put women in that intermediate category no longer exist. But the intermediate scrutiny still exists, and gender still exists there until we have a Supreme Court case that moves gender into strict scrutiny. And then minimum scrutiny, which is everything else. Everything else can be discriminated against. Your wealth, your age, your sexual orientation used to fall here. Your level of mental retardation, all of those fall under minimum scrutiny because there might be a reason why we're discriminating against you on the basis of one of those categories. Again, my father works for the federal government, and he had to retire by the age of 57 because they have a rule that says that, because they felt that the reaction time of individuals once they reach the age of 57 dramatically decreases, and for the safety of the officers, they want you to be able to retire by the age of 57. And so that comes into play there. And so he had to retire. Well, he retired before 57, but he would have had to retire by that point. If you have any issues or you can't remember what falls under strict scrutiny, again, your fundamental freedoms and your suspect classifications, what falls under intermediate scrutiny, which is just gender, and then minimum scrutiny covers everything else. This is a great slide. It talks about the levels of scrutiny, what falls under them, why, what tests do we use to determine it, and what cases that comes into play. We have put in place over time some acts that have addressed the inequality of gender. We had the Equal Pay Act of 1963, which required employers to pay men and women equal pay for equal work. Again, it's hard to monitor. And remember, if you have a law and nobody's there to enforce it, does it really exist? It's really hard to monitor every person and how they pay someone, especially we have an open market society where people can negotiate their pay, and so that makes it a little bit different and difficult to monitor. Title VII of the Civil Rights Act of 1964 prohibits gender discrimination by private and public employers. Again, gives equal protection to men and women in the employment. Title IX of the Civil Rights Act of 1964, again, guarantees that everybody is free from discrimination in the educational setting. It used to be, when I was going to school, it used to make sure that women had the same educational opportunities that men did. That had to do with scholarships and things of that nature. Now, for the most part, Title IX has to do with making sure that somebody can go to school and gain an education without discrimination, period. That means, men can sexually harass women, women can sexually harass men, men can sexually harass men, and women can sexually harass women. So that comes into play. It's just allowing somebody to gain an education without having to be harassed in doing so. We do see many other groups, I wouldn't say copy, but use the same method that was successful by a different group in our society. African Americans in 1954 were very successful with Brown versus Board of Education, with creating equality in the educational sphere for African Americans. And then we see in 1954 also Hernandez versus Texas, Supreme Court struck down discrimination based on ethnicity and race when it came to Hispanic Americans. Again, the Supreme Court over time has been an excellent means of creating equality or litigating equality in our nation by making sure that the basis of our basis of our society, which is the Constitution, recognizes all people. We see Native Americans as well over time receiving reparations for the land that was taken from them, and we see it with Japanese Americans and Asian Americans who were interned during World War II due to discrimination because we were fighting against the Japanese during World War II, and some people their businesses and homes were taken away, and they were put in camps for them to be monitored during the war. And again, we've given money back to those individuals because of the discrimination that was faced by them during that time. And probably the most recent addressing of our Equal Protection Clause came through the GLBT community and the Obergefell case, which now today allows for same-sex couples to marry under the Constitution through the 14th Amendment Equal Protection Clause. So that's Chapter 5. Again, if you have any questions, email me, and I'll see you soon.